Can I sue my employer for negligence in New York? Getting hurt at work naturally raises questions about your rights, especially whether you can hold your employer responsible. In New York, the rules are specific, and most injured workers are required to use the workers' compensation system instead of filing a lawsuit. Understanding when you can and cannot sue helps you protect your benefits and avoid losing your legal options later. New York law makes workers' compensation the primary remedy for most workplace injuries. The system is designed to provide medical treatment and wage replacement without needing to prove fault. Because it is no fault, you only have to show that the injury happened while you were working. In exchange, the law restricts lawsuits against employers, which is why in most cases you cannot sue your boss even if their carelessness contributed to your injury. These rules come from Section 29(6) of the Workers' Compensation Law, which requires workers to file a comp claim instead of a lawsuit against their employer. Workers' compensation offers several types of benefits: full medical coverage for treatment related to the injury, wage replacement equal to 2/3 of your average weekly earnings up to the legal maximum, and disability payments that vary depending on the severity of your condition. Families may receive death benefits if a worker dies from a job-related accident. These benefits are guaranteed regardless of fault, but they do not cover pain and suffering. That is one reason injured workers may wonder about suing, but New York limits lawsuits tightly. There are only 3 situations where you can sue your employer directly. The first is when an employer has no workers' compensation insurance. If the employer failed to obtain coverage, Section 11 removes their legal protection and allows a direct lawsuit. The second is intentional harm, which includes situations like assault or battery. The third involves employers that are exempt from coverage requirements, generally business owners with no employees. These exceptions do not apply to workers, and construction workers remain fully protected under New York law. If you are wondering about filing a claim, timing is critical. New York requires workers to report an injury within 30 days and file a formal claim with the Workers' Compensation Board within 2 years. Special timing rules apply to hearing loss cases, where workers must be away from the noise source for about 3 months before accurate testing. Claims in Queens are handled at the Queens District Office in Jamaica, where workers may request in-person hearings or assistance. Some workers are also affected by the definition of a grave injury, a strict category in Section 11 that includes severe and permanent losses such as death, total blindness, loss of limbs, paralysis, or severe facial scarring. This definition matters when a third party tries to sue your employer. If the injury is not considered grave, the employer is generally protected from those claims. While you cannot usually sue your employer, you may still have the right to sue someone else who caused your injury. New York allows third-party lawsuits in addition to workers' comp benefits. Examples include unsafe property conditions, negligent drivers, and defective equipment manufactured by outside companies. These lawsuits can recover damages that workers' compensation does not provide, including full lost wages and pain and suffering. A lawyer can help you pursue both benefits at the same time. Construction workers have even broader rights. New York labor law provides strong protections under Sections 240, 241, 6, and 200, allowing injured workers to sue property owners and contractors in addition to receiving workers' compensation. These laws cover unsafe scaffolds and ladders, code violations at job sites, and failures to maintain reasonably safe conditions. Because these claims allow financial recovery beyond workers' compensation, they are especially important for workers on major projects throughout Queens and Long Island City. If a third-party lawsuit results in a settlement, the workers' compensation carrier may place a lien on part of the recovery because it paid your medical bills and wage benefits. Settling without the carrier's approval can risk future benefits, and an attorney can negotiate the lien so you keep more of your compensation. Understanding how workers' compensation differs from a lawsuit helps you make informed decisions. Workers' comp is faster and does not require proving fault, but it offers limited financial recovery. Lawsuits take longer and involve more risk, yet they can provide broader compensation. If your claim is denied, New York provides an appeals process through hearings before a workers' compensation law judge, board panel reviews, and further appeals to state courts, all with strict deadlines. If you were injured at work and want clarity about whether you can sue your employer, the circumstances of your case matter. Support is available, and guidance can make a meaningful difference as you navigate your options with care. L Sanchez Law Office, PC, located at 3706 82nd Street No. 304, Jackson Heights, New York, 11372, United States, can be reached at 646-701-7990 to discuss your situation and help you understand your rights with compassion and experience.